When a single sentence given under oath directly clashes with years of carefully shaped public statements, what follows is rarely quiet. That question simple, almost unremarkable, lands differently when spoken inside the solemn chambers of the royal courts of justice. There, between polished stone columns and centuries of legal tradition, it doesn't merely linger. It explodes. Before we go further, if you're finding this analysis valuable, please like, subscribe, and enable notifications so you don't miss what comes next. Because in that courtroom, spoken words don't drift away, they strike. They record, they bind, for someone like Prince Harry, whose public identity has been constructed, contested, and repeatedly reframed through narrative warfare. Testimony under oath is more than a reply. It becomes permanent evidence. The turning point didn't arrive through another tabloid splash or viral clip. It arrived in sworn answers delivered under unforgiving courtroom lights during cross-examination. The Duke of Sussex sat there while a long-simmering legal confrontation with parts of the British press reached its most intense phase. The popular framing calls it a privacy war, a classic underdog story of a wounded royal challenging a powerful tabloid machine. That narrative sells, but it misses the deeper current. The real story is contradiction. Some faint and debatable, others glaring and difficult to reconcile. Contradictions that time does not soften and that now raise troubling questions, not only about Harry, but about the monarchy he left and the father, who still wears the crown. Here's where the picture grows unsettling. This week, as Prince Harry once again appeared at London's High Court, the lenses were trained on him, the press benches were packed, and many articles were already half written. Yet something more significant may have been unfolding outside the courtroom. Inside palace walls. It wasn't only the Daily Mail's legal team dissecting every phrase. It wasn't only court stenographers capturing each moment. According to multiple sources we will explore in detail later, silent watchers, the firm, the crown, possibly even the king himself were paying close attention. And that silence, it appears, may be ending. If you followed this story only through surface headlines, you might have missed the real stakes. The current case, Prince Harry v. Associated Newspapers, is neither the first nor likely the last legal action he has brought. But it may prove the most consequential, not because of the allegations themselves, but because of what they have forced into the open. At its heart, Harry accuses the publishers of the Daily Mail and Mail on Sunday of systematic unlawful information gathering, surveillance, phone hacking, long-running privacy intrusions. To substantiate those claims, he's had to place a fixed, detailed version of his personal history, dates, emotions, conversations, perceived betrayals into the permanent record of court transcripts. Those same events previously existed in the malleable realm of memoir, documentary series, podcasts, televised interviews, and emotionally charged public remarks spread across many years. Now they are pinned down side by side and measured against adversarial questioning. Contradictions do not automatically equal deceit. Memory is fallible. Trauma warps sequence. Feelings tint recollection. Courts, however, are not forums for nuance. They compare sworn evidence against prior statements. In Harry's situation, that means weighing live testimony against spare, against Netflix footage, against podcast episodes, against years of press statements now being held up to forensic scrutiny. Somewhere amid that comparison, alarm signals began sounding not merely for the defense lawyers, but reportedly for others far closer to the throne. Whispers, some tentative and others increasingly consistent, indicate that King Charles may have reached a limit. Behind closed doors, it is said, legal advisors are no longer being consulted merely for guidance. They are being mobilized for protection. Protection of the institution. Protection of the monarchy itself, even if that requires measures directed against his own son. The instinctive reaction is disbelief. A father would never pursue legal action against his child. Surely it cannot reach that point. Yet this is no ordinary family dispute, no holiday tension or strained invitations. This concerns the crown as a constitutional and legal entity. When sworn testimony threatens to erode public trust in that entity, when it risks exposing inconsistencies and decades of official royal messaging, or when it could implicate the palace itself in action carries its own dangers. Imagine you sit on the throne. Your son's courtroom answers begin to chip away at the credibility of the very institution you are sworn to defend. What course do you choose? A public remark? Private distance? Or something quieter, more structural, and far more consequential? According to individuals familiar with royal legal thinking, preparations of that nature may already be underway. The stakes, they say, have never been higher. To understand the gravity. Rewind just a few days. Prince Harry returned to the witness box. The atmosphere inside the court was... Unlike in previous instances, he appeared less rebellious and more fatigued. Yet his remarks remained sharp as he upheld his stance. He asserted that the tabloids had infringed on his privacy, targeted his spouse, and transformed his existence into a commodity for financial gain. Many observers felt empathy for him, as it's easy to envision the distress caused by such constant invasions. However, the atmosphere changed when the defense started their interrogation. Under oath, Harry reiterated assertions he had previously voiced. But now, with the weight of legal proceedings, regarding timelines of discoveries, sources of information, and what was or wasn't known within the royal household. Yet, some of these assertions clash with documented evidence. Certain ones conflict with details in his book Spare, while others contradict statements he made in recent media interviews. This isn't merely uncomfortable. In a courtroom setting, it's risky because the defense doesn't have to demonstrate ill intent. They only need to establish inconsistency. They're constructing an argument not just against Harry's allegations, but against his overall trustworthiness. If that trustworthiness falters during cross-examination, it doesn't merely threaten this particular case. It could create repercussions that extend to other assertions he's made about the palace, family relatives, and private incidents that the palace has never officially disputed until this point. So, let's discuss the royal silence. That stoic, deliberate, and strategic quiet that Buckingham Palace has perfected over decades. The decision not to respond, the no comment at this time, the intentional lack of rebuttal or refutation. It can be misinterpreted as an action, but royal silence is a deliberate void its potential energy. And what we're now picking up through subtle hints, indirect sources, and reliable disclosures is that this potential may be activating. Because when silence turns into a vulnerability, the following move isn't fury, it's legal action. This leads us to the core of this revelation. There's increasing talk that King Charles might be gearing up for a judicial countermeasure. Not via press statements or insiders feeding lines to tabloid columns, but through attorneys, the Crown's legal experts, and official strategic measures. Although nothing has been officially verified yet, the indicators are accumulating. The palace is starting to privately scrutinize some of the claims in Harry's sworn testimony. Internal inquiries are emerging about whether these declarations, now formally documented, could harm the monarchy's image, particularly if they go unchallenged. And perhaps most forebodingly, there are discreet discussions about whether permitting these inconsistencies to remain without opposition establishes a harmful example. Consider the implications. If the king lets his son's testimony stand uncontested on the public record, even if it's not explicitly about the palace, what signal does that convey? To the media, to potential future litigants, to lawmakers, to posterity. Thus, insiders report a straightforward directive starting to echo in influential circles. Summon the attorneys. It's not a warning or a vow, it's readiness. For the monarchy, threats aren't gauged by media coverage. They're assessed by gradual undermining, now before proceeding. Recognize this, we're not aiming to assign blame or exoneration. We're not litigating Harry's suffering, nor dismissing the genuine excesses of tabloid practices. This isn't a personal critique, it's an analysis of institutional dynamics. Because when personal accounts clash with proof, when recollections face judicial examination, and when familial ties intersect with constitutional obligations, concessions must occur. In the coming discussion, we'll trace that strain meticulously. We'll examine the testimony, the misaligned declarations, the instances where the narrative falters, and the understudied choices occurring within Buckingham Palace's confines. Because the situation transcends a mere legal battle, it's a test of reliability, a fracture in royal foundations, and possibly the onset of an unavoidable clash that no party desired. But what followed altered the entire landscape, catching everyone off guard. A courtroom isn't designed for narratives, it's constructed for revelations. That's the key insight. What might captivate listeners on a podcast or evoke sympathy in a blockbuster? Autobiography carries no influence under oath, no substance, no compassion, no flexibility. In court, compassion isn't proof, and feelings don't supersede discrepancies. When facing a defense attorney, the sincerity of your statements is irrelevant. What counts is their coherence. Prince Harry entered that courtroom carrying the weight of his full public past, not only the pain and the scandals, but the archives. His archives. And it's those archives spanning years of interviews, TV features, written accounts, and proclaimed facts that are now being weighed against his testified declarations before a judge. It's a stark shift from my truth to legal realities, and personal narratives don't always match up perfectly. Let's examine the actual events. When Harry testified in court this week, it appeared to be just another skirmish in his prolonged conflict with the UK media. The lawsuit centers, at least formally, on unlawful methods of collecting information by linked publications, such as hacking voicemails, monitoring, and invasions of privacy. However, establishing proof is complicated. It demanded that Harry recount specific episodes from his life in a detailed, chronological manner, not as recollections or symbolic tales, but as precise timelines, dates, sequences, who said what, when, and under what circumstances. This isn't a venue for broad strokes or artistic expression. It's investigative and exacting. In such a setting, even minor discrepancies can undermine the entire case. One of the most closely examined parts occurred when Harry explained how and when he discovered he was under scrutiny, how soon he thought the media had started interfering in his affairs, who alerted him, what proof he possessed, and crucially, what dialogues took place within the royal family at the outset. But there's a complication. These incidents have been recounted previously. Not casually, but with intense emotional depth in his memoir Spare. In the Oprah interview, in Netflix documentaries occasionally with subtle differences or added emphasis to convey a particular point. In a courtroom, though, there's no agenda, only verifiable facts. When the opposing lawyers juxtaposed those accounts, the inconsistencies emerged. This could appear trivial, just a handful of variations and descriptions. But it's significant. Under questioning, reliability hinges not on motives but on accuracy. It's the contrast between stating, "I felt threatened," versus, "On April 12th, I learned my phone was compromised." One is subjective and heartfelt. The other is factual and specific. When multiple versions coexist, particularly in published books or recorded footage, they clash in a legal context, leading to potential breakdowns. To clarify the implications, this isn't about accusing Harry of deliberate falsehoods. That's not the direct claim. It's about whether his court statements align with his earlier public accounts. If they don't, the defense can contend that his memories are untrustworthy. And if he's deemed unreliable, the core of his allegations weakens accordingly. That's the pivotal shift. Once doubt is cast on credibility, the opposition doesn't need to refute every charge. They simply need to demonstrate that the accuser isn't a dependable source of information. The approach is methodical. Highlight one discrepancy, one mismatch, one excerpt from Spare compared to a trial answer. No theatrics, just steady undermining, and it's not only the defense paying attention. Reports indicate that legal experts tied to the royal household are quietly scrutinizing the records, not openly or formally, but meticulously. The unspoken danger is this: if Harry testifies under oath about palace matters and it conflicts with prior public declarations or official documents, then more than his own trustworthiness is at risk. It's the monarchy's. That's when quiet concerns escalate. That's when discussions intensify, transforming personal family tensions into matters of institutional vulnerability. Picture yourself as King Charles. You've upheld restraint, poise, and separation. Your son has spoken out publicly, but you've stayed composed, avoiding retaliation because discretion safeguards the throne. And fundamentally, you're still his parent. But then a sworn declaration emerges that doesn't match your understanding of the facts. Even more troubling, if left unaddressed, it becomes permanent in the archives. What action do you take? Remain silent and allow misinformation to persist, or intervene not sentimentally or individually, but through legal channels? This courtroom episode stands apart from previous ones. Now, the discrepancies aren't solely between Harry and the media. They could extend to Harry and the royal establishment. And it's all under oath, where statements can't be refined afterward. Testimonies can't be revised for better flow, and inconsistencies don't dissipate, they solidify. This is where it becomes particularly awkward, as some of those mismatches aren't insignificant. We'll delve into them thoroughly shortly. But beforehand, it's important to observe the recurring issues. Topics like when Harry became aware of specific media strategies. If royal staff cautioned him, what private talks occurred regarding phone protection. What guidance he got and from whom. These aren't vague arguments. They're grounded assertions with timelines and individuals named. And some of them, let's put it mildly, don't fully correspond to what's already out there. Not by a small margin, but sufficiently so for defense lawyers to highlight emphatically. Asterisk sufficient to prompt royal legal advisors to begin scrutinizing their private correspondences. Enough to revive those subtle, foreboding phrases. Summon the attorneys. But what exactly sparked that reaction? What lone inconsistency could have ultimately driven the monarchy toward pursuing legal action? This isn't about gossip anymore. It's about a single statement hidden amid extensive testimony that could have altered the entire situation. And we'll dissect that shortly. In autobiographies, recollections can be adaptable. In a courtroom, they're proof. That's the phrase nobody wants to encounter, as it strikes profoundly, particularly when you've dedicated years to shaping your own story. When your perspective, your suffering, your reality have been echoed through various media, broadcasts, and top-selling publications. Yet here's the key point. In court, your reality holds no weight if it fails to withstand examination. And that's why this juncture is so perilous for Prince Harry. Abruptly, recollection isn't a secure refuge. It's a risk. Let's proceed cautiously. Everyone forgets details, names, timelines, the sequence of occurrences, especially amid trauma or heightened feelings. That's not unusual. It's not unlawful. It's simply human nature. However, judicial processes don't evaluate memories based on emotional resonance. They assess them by their reliability. And if you're aiming to demonstrate a prolonged pattern of unlawful monitoring across multiple publications, one element is essential above everything: a chronologically coherent account. That's the foundation on which Harry's lawsuit rests. The instant he claims this occurred at that point, or that he only discovered it then, the chronology solidifies. Every subsequent detail must align. If it doesn't, the whole claim grows susceptible not merely to counter-arguments, but to complete unraveling. This is where things start to falter. During his sworn statement this week, Harry faced questions regarding the initial moment he realized he was under tabloid scrutiny, particularly when he first suspected voicemail interception. The opposing side pushed aggressively. Why? Because in earlier discussions, Harry had recounted prolonged unease, a feeling of surveillance, instinctive hunches, sporadic alerts from associates, gut instincts, all comprehensible. But now he required a specific date, a definitive instance. And the date he provided, well, it didn't neatly match his prior public remarks. For instance, in Spare, there's a section suggesting he was aware much sooner than what he declared in court. That's not merely a narrative discrepancy. That's an outright conflict in documented statements. And a single conflict can undermine an entire testimony. Asterisk, let's pause and reflect. Consider how memory operates when unchallenged. It adapts to fit the story. It bridges voids with sentiment. It reforms to suit the current mood. That's what lends memoirs their authenticity. But the legal arena rejects such adaptability. It immobilizes memory. It requires justification for what you recall. What prompted it? Who informed you? What followed? Suddenly, I just sensed something amiss turns into a pitfall. Because if you sensed it back then, why claim you only recognized it afterward? If suspicion arose in 2005, why assert under oath that 2009 was the pivotal moment? And if your book describes confronting palace officials about it, why testify that you didn't voice worries until much later? That's not character assassination. That's courtroom strategy. And it's effective. Because once those fissures emerge, once memory proves pliable, they can be expanded. One inquiry after another, one record at a time. One precise excerpt replayed with exacting accuracy. This is precisely the approach the defense is employing. Not to demonstrate that Harry wasn't targeted by hacking. Not even to show he's fabricating. just to establish that he can't be depended upon to accurately sequence events. And if that's true, then the allegations themselves weaken. The chronologies lose credibility. The connections between cause and effect disintegrate. Now consider the psychological toll. Because this extends beyond the legal realm, it's deeply intimate. Harry isn't a seasoned courtroom tactician. What occurs when an individual's life narrative, shared through extensive interviews and campaigns, is abruptly exposed to a detached analytical review? Is that unjust, or is it the core purpose of judicial systems? It's a harsh clash. One that converts anguish into documentation. One that transforms profoundly private wounds into material for interrogation. And for Prince Harry, it's evident that this proceeding isn't solely about the events themselves. It's about the dependability of his recollections of those events and how steadfastly that recall endures under intense legal scrutiny. You may question why this is so crucial. Why focus on minor memory variances when the core concern is if the media violated laws? Because inconsistency forms the core of their defense. The opposition doesn't have to prove Harry escaped hacking. They simply need to show that his account can't be trusted as evidence of it occurring. And once skepticism takes root, once jurors or judges notice those discrepancies, and once they do, the entire case starts to feel unsteady. It's like taking a single screw out of a sturdy metal framework. The structure doesn't fall apart instantly, but it suddenly seems precarious and unreliable. In the legal world, that sense of instability alone carries significant weight. This situation extends far beyond the immediate trial verdict. It's beginning to jeopardize something much more substantial. Prince Harry's sworn statements aren't confined to the tabloid's misconduct. In recounting events, he naturally reveals details about discussions, reactions, and internal responses within the royal household and family. If these accounts don't match earlier official or reported versions, the palace and by association, the monarchy comes under scrutiny as well. That's the underlying concern we've touched on previously. It's why legal representatives are now being summoned. Any sworn recollection that even tangentially involves the palace creates potential exposure and responsibility for them too. Harry's side may downplay these mismatches as trivial, but the palace sees them differently, especially when the institution's trustworthiness is being quietly reshaped through someone else's testimony in open court. When uncertainty begins to resemble accusation, and when the monarchy's official voice is absent while an unapproved story takes hold, silence becomes impossible to sustain. So here we are, Prince Harry testifying under oath, outlining a sequence of events that subtly yet clearly diverges from his previous public versions. The media is observing closely. The opposing lawyers are probing for weaknesses, and within Buckingham Palace, quiet deliberations are underway whether to step in directly or to ready a response. What Harry said next crossed a critical threshold. It wasn't merely a minor inconsistency. It explicitly referenced a royal staff member in a private conversation held away from public view. That one detail may have finally breached an unspoken boundary. Not every institutional response plays out publicly, but certain silences speak volumes. The public has followed Prince Harry's courtroom confrontations like a gripping streaming series paparazzi outside the High Court. Dramatic headlines about royal clashes, commentators dissecting his words like play-by-play analysis. Yet they're only seeing part of the picture. The real action is happening offstage, while cameras focus on Harry's expressions during his testimony. A more subdued development is taking place elsewhere, a deliberate quiet from Buckingham Palace. This isn't the silence of indifference, it's the silence that signals intense activity behind the scenes. In ordinary families, public allegations from a relative might spark direct confrontations, heated calls, explosive messages, or outright estrangement. In the royal world, responses follow strict protocol, measured restraint, formal denials if needed, and often action conveyed through careful inaction or statements that communicate without saying much. Until recently, the palace maintained its classic stance, stone-faced, unresponsive, unmoved, as Harry aired grievances through books, interviews, documentaries, and now the witness stand. But something has shifted. They're no longer simply immobile. They're choosing strategic silence while preparing. Reports from sources familiar with royal legal strategy indicate that palace attention intensified once Harry's courtroom evidence moved past tabloid tactics and began brushing against internal royal matters-specific conversations. What was said or not said by palace insiders? Actual events and individuals rather than mere speculation or media spin. The defense concentrates on highlighting contradictions in Harry's accounts. The palace, however, is more concerned with containment, preventing any official distortion of what occurred within an institution defined by tradition. Confidentiality and, above all, public confidence. The stakes became stark when Harry testified about receiving advice from a royal aide not to pursue or heighten certain press-related concerns. He described raising alarms about potential surveillance and phone interception, only to encounter apparent dismissal or indifference. If accurate, this suggests the palace was aware of serious issues yet chose not to act decisively. If inaccurate, it places an unverified claim into the official record. Either scenario presents a serious challenge for the institution, one it cannot simply let stand unchallenged. If Harry's narrative remains uncontested, it risks becoming the accepted historical version. It doesn't require definitive proof to endure. It just needs to withstand cross-examination without effective rebuttal. Should that version portray the palace as having overlooked or minimized Harry's warnings about unlawful media practices, it transforms from a private family matter into evidence of institutional shortcoming. The monarchy does not tolerate such perceived lapses in duty without consequence. You might ask, where's the evidence the palace is even engaged? They've issued no statements. Precisely, they rarely do at this stage. Yet seasoned royal correspondents, those who've tracked the family for decades, recognize the signs. Observers are beginning to detect a change in approach. There's a noticeable reduction in off-the-record briefings to the media. More meetings happening behind firmly shut doors. Stricter controls over communications staff. And perhaps most revealing, the increasing involvement of legal advisors in previously internal discussions. The palace isn't gearing up for a media rebuttal. It's bracing for potential courtroom battles if necessary. That kind of preparation tends to be quiet, methodical, unhurried, calculated, and uncompromising. Consider what the palace truly achieves by maintaining perpetual silence. Very little. Every statement Prince Harry makes under oath. Every reference to the royal household, whether concerning AIDS-related matters, private family exchanges, or claims of withheld assistance, establishes a legal and historical benchmark. Precedents like these are risky because they begin to define the framework for all subsequent accounts. Failure to respond can be interpreted as tacit acceptance. Unchallenged silence can read as implied agreement. History rarely distinguishes between deliberate non-engagement and acquiescence. It simply records that the assertion was made and went unrefuted. That's not a minor detail, it's a lasting mark on the record. This is why people with close ties to the institution now describe the current quiet as strategic, rather than indifferent, a deliberate pause before decisive action. The monarchy's classic playbook has long emphasized containment. Don't aggressively counter every story, but endure until public attention fades. In this instance, however, time may not be on their side. This isn't a fleeting tabloid leak or an unauthorized film. It's sworn evidence entered into official court records. The longer these claims remain unchallenged, the more they solidify into perceived fact. The palace therefore confronts a stark decision: allow the story to take shape without their input, or step in discreetly through legal channels with targeted precision. Insiders familiar with royal operations indicate that the second option is actively under consideration. Such intervention wouldn't likely involve an immediate countersuit. Instead, it could take subtler forms, launching a formal review of the sworn allegations, submitting a private legal demand for clarification or withdrawal of specific claims, or conducting an internal examination of the purported discussions with royal aides. Should discrepancies emerge, if no documentation exists for the conversations Harry described, if emails, meeting notes, or witness statements contradict his account, the palace could then proceed, not with emotional outbursts, but with exacting accuracy. The goal here isn't retribution against Harry personally. It's safeguarding the monarchy itself, its reputation, its value as a brand, its historical legacy, its legal position, and its relationship with the media. Much of the public and press focus remains fixed on Harry scrutinizing his every misstep, every pause, every emotional moment. What often goes unnoticed is the subtle activity unfolding out of sight, the discreet phone calls placed, the strategy sessions convened, the attorneys now poring over court transcripts not casually. But as part of their professional responsibility, the palace doesn't remain entirely passive indefinitely. It observes, assesses risks, and when the moment arrives, acts decisively and collectively so the current situation stands. Harry's testimony is now permanently part of the judicial record. His account doesn't merely target the press. It implicates the royal household through alleged conversations, decisions, or failures to act that suggest indifference from the monarchy. Yet no official response from the palace has emerged. The nature of that silence, however, has evolved. It's no longer mere neutrality. It's preparation. What follows may not be a public press release. It could instead involve legal process, perhaps even a subpoena. The next phase won't be defined by Harry's statements alone. It will hinge on what he alleged about a particular individual and on what that person or the institution they represent is now ready to undertake in response. Core principle in this kind of defense is that you don't necessarily have to demonstrate outright falsehood. It's often sufficient to establish reasonable doubt or uncertainty. This understated legal reality forms the foundation of strategies like the one being employed here in court. Credibility isn't determined by who displays the most emotion. It's measured by coherence and reliability over time. When the claimant is a well-known public figure with a long history of emotive public storytelling, the effective tactic isn't to challenge the hurt itself or even the broad narrative directly. Instead, the focus shifts to undermining the framework, the timeline, the details, the consistency. That's precisely the approach Associated Newspapers appears to be taking. Let's be clear from the outset, this litigation was never intended to debate or deny Prince Harry's personal suffering. The legal team for the Daily Mail isn't tasked with questioning whether he endured hardship. Their role is far more clinical, to demonstrate that his testimony cannot be relied upon as accurate if his evidence shows inconsistencies, contradictions, or vulnerability under scrutiny. The foundation of his entire claim weakens not because privacy rights don't matter, but because he may fail to substantiate that those rights were violated in the specific manner he alleges. This methodical style is a favorite among defense attorneys not because it's dramatic, but because it can be devastatingly effective. Rather than relying on theatrics or personal attacks, they build their case through patient, relentless scrutiny of sequence, recollection, and underlying intent. From what's publicly known so far, their current strategy centers on establishing not deliberate deceit, but rather a pattern of uncertainty. They aren't required to label Harry a liar outright. They simply need to reveal that key elements of his version of events have varied or shifted over time. Legally, this creates inconsistency in material facts. To a judge or jury, it erodes confidence in the overall account. Doubt serves as the adversary to solid evidence. Now, consider a particular strategy they're employing, cross-referencing sworn statements with publicly available content. This includes all of Harry's comments from interviews, documentaries, speeches, his memoir Spare, and even remarks from Meghan, which are now treated not as mere rumors but as potential inconsistencies to highlight. For instance, if Harry testifies in court that he learned about the phone hacking in 2010, yet in Spare he describes the initial suspicion arising in 2005 following a talk with William, that 5-year gap might appear minor. But for a defense lawyer, it's an opening a point of leverage. They don't have to outright accuse him of dishonesty. They simply pose the question, which account should we trust? They're also scrutinizing the origins of his convictions. A lot of Harry's allegations stem from his instincts at the time, a gut feeling that things were off, a sense of being surveilled or partially recalled discussions. That's authentic and relatable, but in a courtroom, emotions don't equate to verifiable facts. The defense exploits this by probing, who informed you about the hacking? When precisely did they say it? Did you challenge the source? Can you provide evidence of that exchange? When replies are unclear or approximate, the harm is inflicted not due to falsehoods, but because of the lack of specificity. This underscores the harshness of legal tactics. They don't value fervor. They penalize vagueness. In a lawsuit where the plaintiff's trustworthiness hinges on heartfelt recollections, That's the spot they target repeatedly. Until the compelling emotional core of Harry's narrative, what resonated so strongly with the public appears weakened. Under judicial scrutiny. Another approach they're using is reallocating the onus of proof. It may sound procedural, but it's straightforward. When Harry asserts something like a journalist accessing his voicemails, they insist on substantiation. If he mentions being informed by someone, they demand the identity. If a name is given, they request records of the discussion. Without it, they portray the absence of evidence as a sign of unreliability, not deceit, just uncertainty. They erode the base methodically until the tale, though still moving on a personal level, fails to satisfy legal standards. And that's sufficient for their purposes. We shouldn't view this as impartial. There's an unsettling, almost aggressive quality to these defense methods. They transform complex, sentimental, inherently human ordeals into rigid chronologies and inconsistencies. They're crafted to trap witnesses in instances of doubt and then capitalize on that indecision as a flaw. Yet, that's the nature of the judicial process, and Harry's legal advisors were aware of it from the start. That's why this trial extends beyond mere facts. It's about who dictates the story once the usual narrative freedoms are removed. While the audience might frame it as Harry against the media, the defense is strategizing for the long term. Each time Harry errs on a date, adjusts his statement amid scrutiny, or retracts an earlier suggestion, they're building an alternative account, a secondary storyline where Harry isn't portrayed as a victim but as an inconsistent storyteller. And that version is what they aim for the judge and society to retain. This leads to a nuanced but crucial aspect. There's unverified talk that Associated newspapers could be gathering more than just excerpts, possibly collaborating with other outlets to chart Harry's public statements over the years. The reason? Every instance Harry has addressed media overreach creates a reference point. When those don't match up, the defense leverages them not to deny the underlying truth, but because discord alone is damaging. And in litigation, such discord can be ruinous. This explains the growing unease at the palace. As Associated Newspapers mounts its defense, it's also assembling a chronology that extends beyond Harry. If he claims he shared details with aides or received alerts from within the royal household, and those assertions are now formally challenged, the institution itself gets entangled in the discrepancies. That's why, privately, Buckingham Palace's legal team isn't dismissing this matter, they're monitoring it closely. The resolution doesn't merely impact Harry's case. It influences the official history. And that history is being shaped through each interrogation. But what occurs when this alternative storyline, the defense, is subtly crafting, clashes with the palace's reticence? What if they can no longer remain silent? Because a recent statement from Harry didn't just oppose the media, it conflicted with the palace's internal records. And now it might be too. It's too late for Prince Harry to retract or revise now. Books endure forever and sworn testimony carries legal weight. The real problem arises when the two clash, and that's the uncomfortable truth few want to acknowledge, even those intimately involved. What began as something that felt empowering, essential, and cathartic at the time has now turned complicated. When Spare was released, it was celebrated as a bold, unfiltered revelation, a royal figure stripping away layers of institutional protection to finally speak authentically. Yet legally, every word in that memoir is now fair game as evidence. Every story, date, and memory has become admissible in court. Once Harry stepped into the witness box and took the oath, his book transformed from a personal memoir into a verifiable record. Any misalignment between the book's contents and his courtroom statements isn't merely embarrassing, it's potentially catastrophic for his case. Consider the clear inconsistency right away. In his recent testimony, Harry recounted first realizing the press was singling him out, citing a private conversation with a close royal aide who reportedly urged him to drop it, move forward, and avoid stirring trouble. But Spare tells a different story in ways that start to unravel under scrutiny. His lawyers might contend that the book was never intended as a factual legal document, rather a subjective, emotional recounting. That's fair enough. Still, the opposing side isn't focused on proving malice. They're methodically sowing reasonable doubt. By juxtaposing his sworn words with direct quotes from the memoir, they quietly demonstrate to the court these accounts can't both hold up. It's not a frontal assault, it's precise and incremental. Chipping away line by line, digging further. There's a striking passage in Spare where Harry describes feeling utterly isolated in his concerns about media intrusion, suggesting the palace provided zero backing and dismissed his worries. Yet in court, he testified that palace advisors had acknowledged the likelihood of hacking, offered warnings, and held internal discussions validating his suspicions. Those versions are fundamentally incompatible. Either he received reassurance and confirmation, or he was left in the dark and unsupported. This isn't trivial inconsistency. It undermines the core emotional narrative he's presented to the public. If the court views that foundation as shaky, his overall claims lose credibility, not because they're outright wrong, but because they're inconsistent and therefore less convincing. And inconsistency is often enough for the defense to succeed. Legal experts refer to this as the memoir trap. A high-visibility figure publishes an emotionally charged public story tailored for sympathy and resonance, only to face a judicial process that prizes factual precision over feeling. The earlier version crafted for impact becomes a liability. Poetic phrasing turns into evidentiary ammunition. Metaphors invite dissection. What once felt like reclaiming agency can start to look like an unreliable account, even if the intent was genuine. This highlights a hidden peril of public life when your struggles, healing, and personal history are shared widely and commercialized. They become permanently searchable and comparable. Harry has repeatedly embraced that exposure to his credit. But in a courtroom, vulnerability offers no shield against rigorous cross-examination. There's an added dimension. Spare wasn't merely a book, it served as a calculated tool in a broader battle for control of the narrative. It sharply depicted the palace as distant, uncaring, and complicit. Now, those very accusations are under microscopic review in court. The memoir didn't just target the press. It suggested institutional negligence or worse from within the royal household. That was controversial then, and it's legally perilous now. In testimony, Harry appears more measured, dialing back some of the book's sharper edges, perhaps mindful of perjury risks and consequences. The book, however, remains fixed and unapologetic. Effectively, two conflicting versions of events now coexist in the public and legal record. And the palace is monitoring both closely. The deeper danger: if the memoir portrays royal negligence while sworn evidence doesn't fully corroborate it, the institution isn't merely embarrassed, it could be compelled into a defensive stance, potentially responding not with words, but through formal legal action. One final subtle but significant discrepancy stands out. When questioned in court about the precise moment he began documenting his growing suspicions, Prince Harry faced intense questioning about press intrusion during his testimony. When pressed, he appeared uncertain and hesitant in the witness box. Yet in Spare, there is a strikingly clear and detailed passage in which he describes meticulously jotting down his suspicions, recording unsettling incidents, chronicling moments that struck him as wrong. That written account is vivid, assured, and unequivocal. In court, however, that same certainty evaporated. The defense naturally seized on the discrepancy. Memory that falters under oath but flourishes on the page inevitably invites skepticism. This is the core dilemma of the memoir. It isn't really about embellishment or deliberate distortion. It's about the jarring contrast between two portraits of the same person, one crafted to invite public sympathy, the other constrained by the strict demands of legal truth. The wider the gap between those versions grows, the more vulnerable he becomes not only to the press in the courtroom, but perhaps most critically to the institution he was once part of. As these inconsistencies accumulate, a single, increasingly insistent question circulates behind closed doors. What else in the book might not withstand scrutiny? And what happens when that question moves from speculation to formal examination? When the palace remains silent, it does not signal disengagement. It signals deliberate choice of terrain. This is the misunderstanding many people make. The royal family is not merely a family. It is an enduring institution. Institutions do not issue impulsive statements or respond to every accusation, slight, or tabloid splash. That quiet you notice is not indifference, it is strategy. In this instance, Prince Harry's sworn testimony has extended its implications beyond the tabloids and into the very edges of the monarchy itself. The silence has therefore evolved. It is no longer a simple pause. It has become tactical restraint. Consider the subtle shift. When Spare was published, Buckingham Palace issued no official refutation, nor was one anticipated. The institution has endured wars, abdications, untimely deaths, profound scandals. And the loss of Diana, it has long mastered the art of absorbing blows and biding its time. This time, however, the context is different. Harry is giving evidence under oath in a formal legal proceeding. He has spoken at private internal discussions and leveled accusations at unnamed senior royal aides, alleging they withheld or suppressed vital information about press intrusion. Words uttered in court do not merely fade, they are preserved, transcribed, and carry lasting weight. When those words concern the palace and go uncontradicted, they begin to settle into the public and historical record as unchallenged fact. The palace understands this reality perfectly. That is why the current silence is not passive. It is preparatory and watchful. Royal observers are accustomed to parsing minute signals, measuring the distance someone walks behind the sovereign, decoding the significance of a brooch or a brogue, reading no comment as either détente or concealed hostility. But the present situation transcends symbolism. It involves legal positioning. Multiple sources indicate that palace legal advisors, previously kept at arm's length on this matter, have now been pulled directly into high-level discussions, not merely as listeners, but as active counselors and planners. Such involvement only occurs when the institution perceives genuine exposure. The danger is not that the palace will be named as a defendant. The danger is that it will be gradually conscripted, against its will, into Harry's narrative as an unwilling character in a story it never chose to author. Make no mistake. No one at the palace desires open conflict with Prince Harry, yet the monarchy's duty transcends personal ties. Its overriding responsibility is to safeguard the crown, an obligation that is constitutional rather than emotional. If Harry's courtroom testimony creates even the impression that senior palace figures ignored, mishandled, or deliberately concealed evidence of unlawful press behavior, the consequences reach far beyond unfavorable headlines. That would represent a potential failure of institutional duty. If left uncontested, the damage to the monarchy's credibility would be permanent, immune to damage control via pleasant photographs or seasonal messages. It would remain embedded in the record forever. Timing compounds the difficulty. This controversy is unfolding during a delicate transitional phase. The monarchy is still recalibrating after the longest reign in British history. King Charles's rule is in its early defining stage. Public confidence is still coalescing. The Prince and Princess of Wales now carry heavier symbolic burdens. In such a fragile moment, unchallenged testimony that suggests the palace knew of wrongdoing but failed to act, or worse, suppressed it, can inflict disproportionate harm. Once that perception takes root, its legal truth matters less than its persistence. Narratives of that kind do not merely bruise. They spread and deepen. Already the atmosphere in parts of the British press is changing. Where journalists once treaded lightly around any suggestion of royal legal exposure, some are now more openly naming law firms historically linked to the monarchy, quietly consulting former palace figures off the record, and aligning public relations timelines with courtroom developments. The shift is understated but unmistakable. The palace is neither confirming nor denying Harry's allegations outright. Instead, it is observing, collecting information, assessing risk, and preparing for whatever step comes next. If you're viewing this from Buckingham Palace's standpoint. After enduring endless months and years of allegations, media appearances, and published books, the natural reaction might still be to maintain a dignified distance. However, this situation stands apart because it's no longer purely about image, it's now a matter of legal process. If Prince Harry's sworn statements are permitted to stand unchallenged in the official record, especially those touching on private discussions, advisor exchanges, or supposed alerts that were heeded or dismissed, the palace can't plausibly claim non-involvement anymore. It's drawn in not voluntarily but through association. And there's nothing more harmful than facing accusations without a response. As quietude can come across as tacit consent, this aspect is particularly noteworthy, based on insights from at least two reliable sources in legal journalism circles. The palace has conducted an internal review of the communications Harry referenced in his testimony, including emails, summaries, and records from meetings. Why undertake this? If Harry's under oath assertions turn out to be unverifiable or misrepresent events, the palace faces two pressing duties: to set the public record straight and to establish a clear legal distinction from his account. In straightforward language, this involves erecting a protective legal barrier between his statements and the monarchy as a whole. That effort is already underway discreetly, sans any formal announcement, but undeniably so. This is the palace's method of defense, not via splashy news stories, but through attorneys, established traditions, image management, and above all, a calculated silence that isn't indefinite. It's timed precisely to be tactical and brief enough to deliver a powerful impact. The twist here? For a long time, Harry has criticized the palace for its detachment, for failing to back him during his toughest times, and for resorting to evasive statements like recollections may vary rather than owning up. Yet now, with his testimony posing a risk to the crown, that very detachment is being honed into a sharper tool, something more targeted, something that could lead to legal action. While Harry shares his personal truth, the palace might be gearing up to contest the factual precision of it, not via a televised chat or public statement, but through a formal court document supported by evidence and the weight of royal endorsement. Thus, the key query arises: should the palace end its reticence and finally respond, will it do so as a familial entity or as a formal organization? There's a strong chance that the monarchy's next. Communication won't come in the form of address, it could arrive as a legal document. You don't have to be defeated in court to feel the fallout. That's the harsh reality few want to confront, particularly in a scenario like this where opinions are shifting and the entity at stake is both vulnerable and steeped in history. Legal vulnerability isn't always synonymous with culpability. At times, it manifests as a silence that can no longer hold or as an inquiry posed in court that lingers unresolved. Other times, it appears as enduring harm irreversible and persistent, even absent any official blame. Let's revisit the palace's perspective. By now, Prince Harry has delivered testimony under oath that not only targets the media but also draws in the royal apparatus. He's recounted instances of internal passivity, hinted at awareness among unidentified palace staff, and implied a deliberate choice to withhold protection from invasive legal actions. No specific individuals were called out, but that's arguably more problematic, as the insinuation diffuses broadly like lingering haze that sticks to everything. Within the monarchy, such insinuations can be nearly as destructive as concrete evidence, since unlike gossip rags, they don't thrive on controversy and counterstatements, they function on heritage. And heritage falters in the face of uncertainty. This encapsulates what we term exposure absent a ruling. Suppose the court rules in Harry's favor, he secures compensation. The media is deemed responsible, no issue. But if the proceedings highlight the crown's apparent inaction, portraying aides as indifferent, unassisting, or subtly involved, then his triumph equates to the monarchy's setback. And if Harry doesn't prevail? If the evidence is deemed inadequate? The damage from exposure persists regardless, as the most incriminating elements aren't confined to the verdict, they reside in the records, in sensationalized reports, and what the public chooses to remember. The trial shifts from being about the decision to what embeds itself in collective awareness. This is the bind ensnaring the palace, not due to any action it took, but because of what it omitted. No advanced clarification, no proactive safeguard. Now the institution is linked to another storyline. In a framework where harm can occur without a formal decision, Harry's documented words alone suffice. It's enough that royal attorneys are responding, even if unacknowledged. Enough that reporters are citing not rumors, but authenticated court transcripts. And those transcripts will endure eternally in repositories, in films, and upcoming narratives, asterisk books on the gradual decline of the monarchy. This represents legal vulnerability even without a formal judgment. Consider a real-life parallel. When a company faces allegations of misconduct, it frequently prevails in legal battles, yet it still suffers damage in the public eye. Share values drop, confidence from the public wanes, and executives step down not due to a courtroom defeat, but because the proceedings themselves subject them to intense examination they can't endure. The situation here is similar. The royal family might never be directly implicated in this legal action, but it has already been pulled into the fray through indirect references, through what's left unsaid, through explicit statements and notable silences. And it's not only the royal institution enduring this subtle deterioration, Prince Harry is affected as well. If inconsistencies in his account emerge, even without proof of deceit, those discrepancies can create rifts in his ongoing trustworthiness, in relationships with former public supporters, and in the carefully crafted story he's upheld since withdrawing from royal duties. Verdicts provide clear resolutions, but the effects of revelation spread like an infection. It doesn't remain limited to a single news story or courtroom session. It infiltrates all aspects, forcing everyone to acknowledge their involvement. There is an additional dimension, the long-term perspective of the institution. The monarchy thinks in terms of generations, while Harry's lawsuit could wrap up in mere months. However, the residues, those inconsistencies and inferences, will be exploited for years to come. In every upcoming royal scandal, every movement against the monarchy, every sensational media revelation, this case will be cited as a benchmark. Not primarily for its outcome, but for the statements made, the errors left unaddressed, the denials that never came, and the lingering doubts. This is likely causing quite alarm at the palace. If they issue a public response now, they elevate the significance of Harry's accusations, inviting more scrutiny and potentially strengthening the storyline they've sought to transcend. Yet, by remaining silent, they let those accusations solidify and take root. Suddenly, it's not just Harry alleges X, but Harry swore under oath to X. And the palace offered no rebuttal. That difference will resonate in historical accounts, in future films and series, and in subsequent controversies where patterns are scrutinized. This explains why entities like the monarchy dread legal proceedings even if they're not directly involved. Courts preserve recollections, transforming fluid stories into fixed declarations. They establish enduring documentation not only of facts but of assertions. Once a statement is recorded under oath, its influence hinges less on accuracy and more on endurance, whether it's refuted or contested. Here, the palace's reticence is unexpectedly conferring a form of unspoken validity to Harry's recounting. Even absent judicial endorsement or confirmation, it remains unchallenged, growing more entrenched with time. So, what's the path forward? Should the palace submit a formal document? Issue a precise public declaration? Permit third-party legal representatives to contest elements of Harry's evidence? Are they willing to convert their quietude into open conflict, given that the scrutiny is already upon them? The final decision might be irrelevant now, as the disclosure has already occurred. However, their upcoming action could alter the dynamics entirely, since just as the palace observes Harry, he might be monitoring them in return. If they show any sign of unease, he could capitalize on it. Every legal matter reaches a stage where vigilance turns to intervention, where passive observation falls short. This is that juncture not when a claim is voiced, but when it endures. Not when the palace is explicitly named, but when the underlying suggestion demands attention, for weeks perhaps. Even years, Buckingham Palace has maintained its composure. This extends beyond reactions to Harry's public assertions to the escalating rhythm of legal repercussions encircling them. They've relied on their restraint, banking on the monarchy's traditional safeguard, detachment. But detachment succeeds only when boundaries are distinct, and now those boundaries have vanished. Let's examine the shift. Until recently, Prince Harry's lawsuit against associated newspapers was essentially his personal battle, his narrative, his claims suffering from an aggressive media landscape. It was a recurring theme in British news, reminiscent of Princess Diana's experiences, portrayed as a contemporary underdog challenging a giant. Yet a change occurred in his recent testimony. It was an understated instance, perhaps overlooked by the general public but caught by legal experts. Harry recounted a private discussion with a high-ranking royal advisor. The backdrop was standard: concerns over phone interception, accumulating proof, rising tension. But his phrasing struck a new chord this time. He didn't merely imply apathy. He indicated knowledge. That the palace was aware, that they recognized the probability of unlawful breaches. And beyond that, they recommended he avoid pursuing the matter. Now, stop and reflect on the implications of that. Asterisk. The issue has moved well beyond a simple grievance that the palace failed to support Harry. The claim now is far more serious. that the institution knew criminal activity was taking place and deliberately chose to keep it hidden. That shifts the matter from a private family complaint into an accusation of institutional complicity. Although Harry has not publicly identified specific individuals in court, he does not need to. The implication is clear enough for both the defense team and the palace to understand exactly where the signal points. If the monarchy did in fact receive legal advice or intelligence reports detailing press misconduct, and if senior figures decided to minimize, suppress, or ignore that information, and if that choice is now part of unchallenged court testimony, then the situation has crossed an important line. What began as narrative management has become genuine institutional exposure and legal risk. This is the critical threshold. From this point forward, the palace can no longer afford to remain a passive bystander in Harry's legal proceedings. They are not formal defendants, but they are rapidly becoming named or strongly implied witnesses in a historical and potentially legal record. Even without a subpoena or criminal charges, one unavoidable question now hangs in the air. Did the monarchy as an institution consciously permit harm to come to its own members because confronting the press would have created even greater disruption? When that question remains unanswered, silence itself starts to function as evidence. History offers plenty of precedents, not in royal settings, but in other powerful institutions, the Catholic Church, major corporations, government agencies. There is always a tipping point where internal awareness turns into public implication, and the protective silence that once shielded the organization begins instead to condemn it. The monarchy is not exempt. Its apparent immunity has always been cultural rather than strictly legal. And cultural tides shift far more quickly than courtroom timelines. People close to royal advisors, speaking privately, of course, now indicate that a tipping point has indeed been reached. Preparations are reportedly underway, draft official denials, carefully worded clarifications delivered through intermediaries rather than directly from the king, and even preliminary work on an internal timeline of actions not for immediate release, but as a defensive record should the matter escalate beyond the present trial. Why create such a timeline? Because the primary task of legal advisors is to contain liability. The danger is now unmistakable. Should Harry's evidence stand and influence a favorable ruling? And should a judge or panel refer to the royal household's apparent failure to act, the crown would find itself cast publicly and perhaps historically in an entirely new and constitutionally intolerable role. A participant in the failure rather than its innocent victim. Timing is therefore everything. Move too early and it appears defensive and guilty. Wait too long and the institution risks being retroactively defined as complicit. So the palace calibrates. It tracks media coverage, gauges public mood, listens to how resonant the growing silence has become. Then, at the precise moment when intervention can still shift perception, it will act not necessarily by confronting Harry head-on, but by moving around him. Possible steps include selective disclosure of evidence to undercut particular assertions, discreet media placements that quietly correct dates or context without formal rebuttals, or allowing trusted former aides and retired staff to offer personal recollections that align with the palace position. Every element would be coordinated, deniable, and carefully timed to halt or reverse the current momentum, because this litigation has outgrown its original scope. It is no longer solely about phone hacking. It is about institutional responsibility. In the British monarchy, responsibility does not remain with individuals, it travels upward until it reaches the crown. Leave the question unanswered long enough, and responsibility solidifies into ownership. In this context, ownership would carry historic and potentially existential consequences for the institution. What happens next depends largely on how much further Harry is willing to push. He has already gone beyond what many anticipated, placing raw emotion and direct challenges to both the press and the enabling system on public record. But if he moves from implication to explicit naming of the culture of individuals, of specific decisions, and if even one forthcoming statement directly alleges that a senior royal knowingly permitted a criminal act to continue without any attempt to intervene, then the palace's calculus changes instantly. The question will no longer be whether they should respond. It will be how quickly they can mount an effective defense before the accusation hardens into accepted history. Thank you for watching and see you the next video. Bye bye.